All right, so we're good to go. So we're very happy to welcome everyone to a new year of update meetings and 2023 is well underway, obviously, and there's been a lot, as typically the case, that happens in uh, our estate planning world. And we want to share that information with you today and give you some food for thought and also help you prepare for your own individual meetings during the course of the year. We'll talk a little bit about just the process to make sure everyone's up to speed on how we do it and what you need to know going forward. So what I'm going to do, I'm going to share the screen and get the PowerPoint up and running here. Everyone can see that, I hope, at this point. Just a few normal housekeeping matters. If you do have a question, there's a Q&A box that you should have access to on your side of the Zoom. By all means, just post that in the box. Either Megan and I will answer your questions and be happy to try to clarify any points of confusion or need for clarification. So without further ado, we're going to proceed ahead. So let me go there. And just as we always do, we talk about what's transpired a little bit in the law firm over the last year. Last summer, we had two important events. We were joined by attorney Barbara Garigliano up in Monticello. So she and her husband Walter had a firm for many years, definitely two of the more preeminent attorneys in Sullivan County, and Barbara has joined us. Walter is tangentially with us, but for various reasons he couldn't actually join the firm. But they're a great resource for us up there for any land use and real estate matters, and just added to a stable of the top flight attorneys that we have in the office. More for our purposes, last August, our funding coordinator, Richard Martino, a new funding coordinator, joined the practice. Sarah, who had been with us for about 10 years, I'm guessing, thereabouts, 8 years.
Yeah, probably close to that.
Yeah, she and her husband moved down south, and we were sorry to see her go, of course. But Richard has stepped in and has really gotten up to speed and is a very diligent, conscientious person. And for those of you who haven't had the opportunity to work with Richard, I'm confident you'll find him to be a great resource for your needs. And he works very closely with Megan, May, and myself. So any sort of funding related matters, you're probably best just going directly to Richard Martino, and then he can direct anything to the attorneys as necessary.
Yeah, and if you're calling to ask for one of the Richards, you're going to have to be specific going forward.
That's very true. That does, we have a few Sarahs in the office, now we have two Richards, so always an interesting development there. That's right, I'll get calls. So, someone said to call Richard. I said, which one? So anyhow, a couple other things, just always nice, a little feather in our cap. I was in 2022 fortunate enough to be named one of the top 25 lawyers in the Hudson Valley by Super Lawyers, and again was in their elder law list for upstate New York attorneys. Megan was also recognized as a rising star, which is even more exclusive. The regular Super Lawyers is the top 5%. Rising Stars is limited to top 2.5% of attorneys either under 40 or have been practicing for less than 10 years. So hopefully you feel confident you have the right people here to handle your needs. So why don't we move ahead and talk about some of the document updates. So I'll turn that over to Megan, let her run with that a bit.
Sure. So every year we try to update you on some of the changes that we have available to us for our documents that we might start incorporating in your documents, which is why it's important to always come in and sign these updated documents. Even if you tell us that you don't have any changes, we're kind of always tweaking things and trying to improve where we can. We do use software to help us with a lot of the heavy lifting for the drafting, and then we do a lot of customization thereafter. So your documents are always a combination of both The software that we use has improved in the way of giving us some additional sort of foundational templates that we can use as a springboard to then again further customize for your purposes. So our software has included some trustee acceptance and appointment forms. So not something that you're going to find incorporated in your restatements necessarily, in your trust documents specifically for those forms, but it does allow us to accommodate you more efficiently if you do have something that needs to be changed, or maybe it's a successor, you've lost capacity or passed away and it's in the administration portion of our services. This just makes it that much easier for us to address that need very quickly if we need to. We have the option to include something called the Slayer provision. And so this is available in your trust documents and probably even the wills if we really wanted to include this. What the option does is it allows us to bring in a provision that says that any beneficiary that causes the death of the trust maker or maybe one or more of the other beneficiaries cannot receive an inheritance. So kind of having this contingency to say, yes, I want them as a beneficiary, but if they caused my death or killed somebody else who's a beneficiary of my estate, then I don't want them to serve as a beneficiary. And you may not be around to make that change. So we have this springing provision available. So that's something that you can think over. If you want to include it, you're going to have to let us know. I don't know that everyone's going to jump at that one, but we just want you to know that it is something that's available. A little bit unusual, but it's there if you want it.
Yeah, and I will say in my 34 plus years of practice, I fortunately have never had that come into play. So I don't know why our software folks thought it was really necessary to include it. In fact, under New York law, there's a forfeiture anyway if one of your beneficiaries causes your death. So while we're certainly happy to include it, if you insist on it, you might need family counseling or some other issues beyond what we can help you with. But it's just somewhat more of a humorous thing, in my opinion, than a practical need. But we want to let everyone know what's available, and then there you go.
Right. For our trust advisor provisions, this is something that I try and I'm sure May going forward will try to review with you guys as it comes up in reviewing those documents during the restatement. But the trust advisor is typically a large portion of your trust instruments that builds in some flexibility, really allows your successor trustees, your beneficiaries, even yourselves, depending on the circumstances, to bring in new provisions or changes to some of your trusts, even when those trusts normally wouldn't be flexible enough to allow you to do that yourself. And so in those trust advisor provisions, we've had a little bit of an update here. We're giving the trust advisor the authority to amend the trust so that a beneficiary will no longer qualify as a designated beneficiary for retirement plans. And so the retirement language that we have is very complicated. And I'm sure you can imagine that's because the rules for retirement accounts are very complicated. And this provision says that although we may have done a lot of complex drafting to make sure that when your beneficiaries inherit those retirement accounts through the trust instrument, if that makes sense, we can just as easily go in and say, you know what, the circumstances don't call for this language anymore. And so now we're actually better off if we change the language, even if that means your beneficiaries will no longer qualify as this special term using the designated beneficiary. So again, it just gives us the flexibility. I can't imagine too many circumstances where we would want to utilize this, but who knows, right? We can't predict the future. And so this is just one of the places where we're saying we don't want to be prohibited from making a change if it would be to your benefit or your children's benefit or somebody else, just because we were trying to comply with something that it was a different rule way back when.
Right. And the primary area where this might come into play is that depending on whether a person who's the planned participant of let's use an IRA as a general term of art, a person who is either before the required beginning date, the age when they have to start taking distributions, or after, will determine whether the successor beneficiary is restricted to the 10-year payout term that a designated beneficiary is entitled to, or can use what is called the ghost life expectancy, meaning the remaining life expectancy of the original owner had they still been living. So that's why they call it the ghost life expectancy. And the ghost life expectancy in many cases is going to be longer than the 10-year term afforded to a designated beneficiary. And so in those cases that I'm describing, it would be better not to be a designated beneficiary. And so the trust advisor can toggle off that provision so that the trust beneficiary can now use the longer ghost life expectancy if it would be beneficial to them at that time. So that's the kind of stuff that the retirement planning elements are the most confusing area of estate planning I think we deal with. And we want to have as much flexibility as possible, as Megan alluded to.
We also have the ability to build in some language that specifically speaks to, in a married couple situation, their legal separation or a divorce. So the clause that we have that's available to us is, if my spouse or I file a petition for legal separation or dissolution of marriage, and unless and until the petition is dismissed, my spouse, his parents, we're assuming maybe that this is a female or maybe it's a same-sex couple, but my spouse, his parents, all of his descendants who are not my descendants, and all spouses of such persons who are not descendants of my parents will be deemed to have died intestate on the date of the filing for all purposes of this instrument. So effectively saying, if we file for separation or we file for a divorce, I'm kind of lopping off my spouse's or soon to be ex-spouse's side of the family, right? Him and anyone that would tangentially be a beneficiary of my estate if we were still together. So we're kind of bolstering a layer of protection to say, if this marriage falls apart or it's in the beginning stages of falling apart and I pass away before it's finalized, I want to make sure that my wishes are still met and that that person's family is not inheriting. What was interesting is when doing the research for some cases to present to you today, I also came across a case that said something very similar to what this clause is saying. It was the court found that even though the divorce had not yet been granted, a lot of the paperwork had been prepared and the beginning sort of stages of the divorce were started. Things were filed with the court. And there was really nothing holding up. There wasn't going to be any debate or discussion. There wasn't going to be any custody. There was no issue for alimony or anything like that. It was just going to be a very clear-cut case. And then, unfortunately, the petitioner in the divorce passed away before it could be finalized. And the court said, well, we're going to interpret their estate planning documents in such a way that does exclude the spouse, even though technically they're still married, the divorce isn't finalized. It was all but the court stamping the approval for it. So we do have some case law to back this as well.
Yeah, and you'll notice in the language, obviously, it seems obvious, I guess, to most people that if there is a legal separation, you're going to disinherit your spouse. But this also makes sure to disinherit that spouse's descendants who are also not your descendants. So in the blended family, where we have so many, over 50% probably today are in second marriages, we want to make sure if there is that kind of a rupture in the relationship, you're not inadvertently leaving assets to your spouse's children who are not your own children.
Right. And so this is part of the conversation that we're going to have. It's not something that we're just automatically including because not everyone feels that way. We just want you to know that this is available if you think this is something appropriate for your planning. But of course, everything is unique to your situation. So we'll customize based on your needs. We also have available to us for those who would like to incorporate this in your living will, which is the document for end of life decision making. It's the one that says you don't want to receive any life prolonging care if you decline to something like a permanent vegetative state or comatose state. Now, and some of you already have this, it's just that we've customized the provision. Now we're making it more readily available. Now it says that you can incorporate a waiting period. So once you have declined into that state, that what we're guessing is going to be a permanent vegetative state, but I guess no one's really sure. Once you've declined to that point, you want to give yourself or your family at least a certain number of days. So you'll get to designate the number of days if you want to include this. It's not required, it's just an option. So I have seen some people say, well, once I've declined, I'd like to wait 7 days before you stop giving me that life prolonging care, or 2 weeks or 30 days or what have you. So if this is something that you've been concerned about or sort of toying with, or that living will makes you a little bit uncomfortable, this might be sort of a good hybrid for you to say, all right, I agree, I don't want that care. I don't want to be left in a vegetative state for a long, long time, but give me some time to see if I can maybe crawl out of this. So we do have that available. And I think with your worksheets this year, you're going to get a option form to say if you want to include that.
Right. Yesterday, I had a woman who opted for a 30-day waiting period. Now, certain people, say, well, if I've reached that stage, why prolong the, the definite, or what the medical people say is going to happen. But other people say, hey, miracles happen, right? Why should I forego that opportunity? So this is very much a personal decision. And again, you'll have a form that you can indicate if you do want to put a time frame within the living will. So that's sort of the document update portion. We're now going to talk about, as we always do, the legislative and regulatory update, where the laws are, estate and gift taxes and so on. So the first thing we're going to cover the estate and gift tax exemptions. So people understandably have been very grumpy about inflation over the last year or so. But there's one area where inflation has been very beneficial, and that's in the estate and gift tax arena, because the federal and state estate and gift tax exemptions are tied to inflation. So what you'll notice here is that the federal exemption this year jumped all the way from just over 12 million to just under 13 million. So almost a $900,000 increase in the exemption level, giving a close to 26 million federal estate and gift tax exemption in 2023 per couple. Individually, just under 13 million, of course. Now, as we've mentioned this in prior years recently, there is a sunset provision in the current law that was in effect since 2017, that if Congress doesn't pass new legislation that is signed into law by whoever's president between now and 2026, as of January 1st, 2026, the federal estate tax exemption will revert back to the 5 million exemption that was in effect in 2017, but indexed for inflation from that time. So it'll probably be in the, $7 or $8 million range if that comes to pass in 2026. So that's just something to keep an eye on for people who are a little bit in the higher net worth category. The New York exemption, likewise, is also increased for inflation or indexed for inflation, and that jumped from a little over 6.1 million last year to 6,580,000 this year. New York does not have a separate gift tax. However, there is a recapture. So if people are on their deathbed and have an $8 million estate, and they say, hey, I can give away plenty of money, I won't be affected by federal estate tax, I can get down to the 6.58 million limit. It doesn't work in New York. You have to make large gifts more than 3 years prior to death to have them excluded from calculation in the New York gift tax arena. The annual gift tax exemption jumped from 16,000 in 2023 to 2022 rather, to 17,000 in 2023. That was it was only 1 year at 16,000. For many years, it was fixed at the prior number for years because inflation was so low. So we've seen a lot of change in this area, of course. And what this means, the gift tax exemption, just as a refresher, you can give any person, doesn't have to be a relative, up to 17,000 a year without filing a gift tax return or utilizing any of your federal gift tax exemption, which is tied to the estate tax exemption. Doesn't mean you can't give more than 17,000 per individual. It just means if you do so, you're going to utilize some of your exclusion, your lifetime exemption amount, and will need to file legally a gift tax return.
And just keep in mind that that's only for tax purposes. We are not recommending that you make gifts for Medicaid reasons, right? If we have a concern about long-term care, doesn't matter that you do or do not have to file that gift tax return. It could be problematic for your long-term care. So just be careful when making gifts.
Right. And that's a good segue into the Medicaid rules. There have been some changes this year, as there almost are every year. Very helpful in context here is that the individual resource allowance for community and nursing home Medicaid has jumped, almost doubled. It went up to 30,182 this year from 16,800. And frankly, it wasn't long ago, within 10 years, that the individual exemption was only about $4,000. So we now have a little more cushion when we're filing our applications. And this really comes in handy in cases we'll deal with people, let's say they have one of these relatively small cash value whole life insurance policies, for $20,000 that has like $18,000 of cash surrender value. Rather than having to liquidate it or move or change ownership of that policy, which can be complicated to accomplish, we can just use that cash value as part of the 30,182 allowance and not have to really worry too much about it. So it gives us a little more flexibility and makes it easier to get quick eligibility for Medicaid, both community and nursing home. We've also seen a significant jump in the income allowance for community Medicaid. There's different rules for nursing home Medicaid. If you're in a nursing home and apply for Medicaid, you get to keep $50 a month, nothing more. All of your excess income goes towards the cost of your care, with Medicaid paying the difference. But in the community context, you have a larger exemption, and that has increased significantly from $934 last year to $1,677 this year. If you have more than this number, there's two options. If you're married, one, we can budget some of that income to your well spouse, or we can do a pooled income trust for the excess income. So let's say you had 2,677, you're over by 1,000. Let's assume you're a single person. We can budget and allocate that extra 1,000 a month of income, rather than go towards the cost of your care. It goes into what's called a pooled income trust, which is a type of statutory agreement that is blessed by federal and state law, operated by various nonprofit organizations within the state. They administer it. That extra 1,000 a month goes into that pooled income trust and can be used for your personal expenses, your property taxes, your groceries, your clothing, anything other than having to go towards the cost of your aids, so that Medicaid pays for all that, you pay for none of it. Another change in the community Medicaid rules is what's called the independent assessor system has been implemented. Essentially what that does is that the state now has a contractual arrangement with these independent assessors to determine whether an applicant is in fact eligible for community Medicaid services. That's been now on a statewide basis. It used to be handled by each county Department of Social Services. So they're trying to create more uniformity in the eligibility criteria. So it's a more stringent system. The more you have to show a greater medical need for community Medicaid services. And they're going to take a stricter look at whether the home is a safe environment for that person, that they can live comfortably and not worry about stairs if they have mobility issues, or be locked in a single room because they'd have to use the stairs. So it's not automatic that someone says, I want to be cared for in my home, that the state or county is going to approve that is a suitable environment for you. Now, if care is authorized in the home setting, and the recommendation is for more than 12 hours per day by the assessor, that requires a further review by an independent review panel to verify that those hours are absolutely necessary. As you can quickly determine, all these new rules are to restrict and limit the care that is being provided in the home setting from a budgetary standpoint. That's what the bottom line of all this is. Likewise, before the new rules went into effect, you only needed to prove 2 that you were deficient in 2 of the 7 activities of daily living, such as transferring, getting out of a chair or bed, dressing, grooming, bathing, meal preparation, things of that nature. Now you have to show deficiencies in 3 of those to qualify, except if you have dementia, then you only need 2 ADLs to qualify. So again, trying to make it harder to gain eligibility from a tax, from a revenue and generation standpoint. Now, we've been talking about this for the last 3 years now. The community Medicaid look back period that has been in law since 2020 is supposed to be implemented as of, or the earliest of April 2024, so a year from now. However, just yesterday I saw that our local Senator Skoufis has proposed a bill that would repeal this 30-month look back entirely, so it would never happen. So we don't know if or when it will happen. If the law goes into effect as currently scheduled, just like a nursing home case where transfers in the nursing home context within the last 5 years will create some penalty period. If this does go into effect starting April of 2024, there would be a penalty period imposed for transfers made within 30 months of applying for a community Medicaid application or benefit. And so that's half of what the nursing home look back would be. It'll be very complicated to administer this if they do it. And that's why we're still somewhat optimistic it won't go into effect. And now with the Senator Skoufis's bill, maybe that becomes more of a reality. But as always, we'll keep our client base informed if or when this is actually going to happen. So the other major change is the Secure Act 2.0. So Megan, I'll let you run through these new policies.
Sure. So in December of 2022, President Biden signed into law the Consolidated Appropriations Act of 2023. But that is something that is being referred to as Secure Act 2.0. So if you've heard that, that's what this is referring to. And just keep in mind that the Secure Act is something that we've been discussing with you in these presentations and in the one-on-one meetings since 2020. And that's when the original Secure Act went into effect. And if you recall, that is what really changed. There was a sort of major overhaul for the treatment of your retirement accounts. And from our perspective, specifically, our planning changed because the way that your beneficiaries, whether it's spouse, not much change has happened there, but certainly children and other named beneficiaries that you may have had or designated, the way that they were going to have to take distributions from your retirement accounts when they inherit them changed dramatically because of that Secure Act that was introduced in 2020. So now President Biden has made some additional changes to that, and we're calling that Secure Act 2.0. So some of the key provisions of this revamped Secure Act, the required minimum distribution age starting in 2023, this year, rises to the age of 73. And so we did see an increase in that age with the original Secure Act. And so that was to 72. Now we're up to 73. And then in 2033, that age is going to increase again to age 75. So that's when you start taking your required minimum distributions. You'll be required to take withdrawals.
Right. Just as a, just as a refresher on that, doesn't mean you have to wait till 75. As long as you're over 59 and a half, you can withdraw without penalty. This just now allows you to defer the required beginning date till 75.
Right. Under Secure Act 2.0, you'll no longer be required to take your required minimum distributions from Roth 401ks, which now aligns with the Roth IRAs. So kind of same rule for Roths now. There is a penalty, the penalty for failing to take all or part of your RMD. So as you know, once you reach that required beginning date, you have to take those distributions. And if you don't take them, there is a penalty. The penalty for that used to be 50% of the required minimum distribution amount. So whatever amount you were required to take in that year, the penalty would be 50% of the value. Now that penalty has been decreased to 25%. Some of you are familiar with the catch-up amount. So the amounts that you can contribute into your retirement accounts once you reach certain ages, that's that catch-up amount. So for ages 50 and above, the catch-up has increased to $7,500 starting in 2023. And then starting in 2025, people between ages 60 to 63 can make up to $10,000 in catch-up contributions. But that is going to be subject to the income cap of $145,000 of income in a year. This revamped Secure Act allows for easier access to funds for family emergencies for those people who are under the age of 59 and a half. So for people who have retirement accounts, have contributed to their retirement accounts, but are under 59 and a half, there are penalties affiliated or associated with taking out distributions of from your retirement accounts before reaching that 59 and a half. Secure Act, the first go around, and now in this revamped one, they're making certain exceptions to allow for younger folks to be able to pull from those retirement accounts under certain situations. They want to make sure that these people have a little bit of access to those funds in emergencies and sort of big life events or changes. Beginning in 2025, employees must be automatically enrolled in their workplace plans with the right to opt out. So they're going to be automatically enrolled in those retirement plans, whatever is going to be offered to them. And then if they don't want to make those contributions or be enrolled in those plans, they would have to affirmatively opt out of the plan, which is kind of nice. I mean, not everyone is in a situation to be able to contribute right off the bat, so maybe they'll opt out. But otherwise, as you all know, it's a really good idea for people to start contributing as early as possible from a financial standpoint. So I think that this is a good twist. Beginning in 2024, an employer can match an employee's student loan payments with a retirement contribution. Another nice little bone for those people who do have some student loans or a lot of student loans, many of us out there. So this is another thing that we can look forward to starting in 2024. Also beginning in 2024, unused 529 funds can be rolled over to a Roth IRA for the beneficiary. So another nice way to take some funds that maybe didn't get used because for whatever reason, the person didn't go to college or they didn't have as much financial need as piled up in that 529 account. So now they have that option to roll over the funds into a Roth IRA. So really nice benefit there.
Yeah, I think a lot of these rules are fantastic. The employer match for the student loan payment, it helps so many people struggling with student loan payments that they don't have to necessarily choose, I can't do the 401k. So now if the employer is willing to do that, they can do a match and the students still obviously have to pay down their loan. And the last one is fantastic because, there are circumstances, as Megan said, a person either doesn't go to college or maybe gets a nice scholarship or goes to a less expensive college, and the parent or grandparent, whoever set it up, has all this money left over or some money left over. And what better way to really jumpstart the financial future of that young person than to fund a Roth IRA for that person, because that grows tax-free forever. And if you put 10,000 in a Roth IRA for a 22-year-old, you do the compounding on that, that's going to be worth, well into the six figures by the time they turn 65. So fantastic opportunities.
Yeah. Roth options are now available for simple and SEP plans, often favored by small business owners. So for those of our clients who are small business owners, this may be something you're kind of looking into a little bit here. And then beginning in 2024, employers can set aside up to $2,500 a year in a separate emergency fund for employees making less than $150,000 in this year's dollars, in 2023 money. So whatever the equivalent is in the year's future. So they can set up a little emergency fund for their employees. So really nice way for employers to kind of start helping their employees in other ways than simply, increased wages or salaries. There's sort of other tools available to make sure that everyone is chipping in and helping out where they can, and certainly making the workplace something that is beneficial to an individual in a more well-rounded context, I think. So,
Yes.
Trust for disabled or chronically ill beneficiary is now authorized, may now authorize payment of the trust remainder to a charity upon the beneficiary's death and still qualify as a designated beneficiary. So this is important. There's really stringent rules about who qualifies as a designated beneficiary. And the reason we want to follow those rules is we want to, in most cases, we want to make sure your designated beneficiary qualifies as such to get the best possible distribution method available to them. And one of the restrictions previously is where if we had a disabled or chronically ill beneficiary and then we named a charity as a backup after that beneficiary, right? So remainder beneficiary or contingent in a sense, that person would no longer qualify for the designated beneficiary status. So Secure Act 2.0 has changed that for us from a planning perspective. It's fantastic. We can include charities without being concerned about losing that designated beneficiary status. And so that's what's described here.
Yeah, and I think that's from a drafting perspective, that makes life a lot easier, because many times our clients have wanted to, to my kids and then my grandkids, and if none of them are living, then they want to leave the, the doomsday clause to charities. In the past, we really couldn't do that in our retirement planning structure, and we had to find other individuals who maybe not be the preferred choice. Now we can disregard those charitable beneficiaries in the doomsday clause for designated beneficiary status purposes. And it really frees us up to do what we really want to do and the clients want to do. Did we cover everything here?
Yeah, that's
Okay.
the designated beneficiary. Yep.
Okay, good, thanks. So the Secure Act 2.0 really has improved a lot of the things that were in the original Secure Act, and it'll really make our life and hopefully yours better and easier. So now we're going to talk about a couple of cases. We always like to throw out a couple that sort of show some of the key estate planning real world results, either from good planning or more often bad planning or lack of planning. So the first one is the matter of Goldstein, which was from Westchester County from last August. Very common fact pattern, and you'll see the importance of having the right people do the right things and getting the right advice, frankly. So this goes back in 2006, a woman named Mrs. Goldstein signed a power of attorney naming a guy named David Salvati as the agent. She was a widow, meaning Goldstein, and she had no living children. The case doesn't say explicitly, but it seems to imply that Salvati was somehow related to Mrs. Goldstein. The power of attorney authorized the Salvati to make gifts to Mrs. Goldstein's spouse, children, and more remote descendants and parents, not to exceed 10,000 to each such persons in a year. So as many of the default provisions in the standard power of attorney doesn't allow for gifts in excess of what would have been the annual gift exemption in 2006 of $10,000. So a year after signing her power of attorney, Mrs. Goldstein did a will, leaving her probate estate in shares among Salvati, Salvati's wife Doreen, and his niece, or her niece Lisa, and nephew Michael. That would have been obviously her deceased child's children. Several years later, in 2014, Mrs. Goldstein had a stroke. After the stroke, Salvati went with Goldstein's attorney, who advised Salvati that he could make gifts to himself and other family members up to $14,000 per year, which was based on the increased annual gift exclusion. I'm not really sure that you could do more than 10,000, but arguably you could. There's some debate about that. But regardless, what Salvati did is using the POA, he didn't just stop at the 14,000. He gave a heck of a lot more of Goldstein's assets from her into his own account that he established as a POA account. And troubling for Mr. Salvati's legal standing here is that he is part of these transferred assets included accounts that Goldstein had set up for her, for Lisa and Michael as pay on death beneficiaries. Even more damaging to Salvati's position, he used some of these funds to pay his own personal expenses, including taking care of his mortgage on his house. Following Mrs. Goldstein's death, about a year later, in September of 2015, Salvati, who was executor of the estate, filed the standard estate accounting. Lisa and Michael understandably were not happy once they and their attorneys saw what he had done, meaning Salvati, and they made a claim throughout the accounting proceeding that Salvati had violated his fiduciary duty as agent under the power of attorney by making these large gifts to himself and his immediate family. Not shocking here, the court held that Salvati in fact violated his fiduciary duty to act in Mrs. Goldstein's best interest and avoid conflict of interest. Here, that was important that the power of attorney did not permit gifts in excess of the annual gift exemption, which Salvati clearly violated that restriction. And also important that in excluding Lisa and Michael from making these gifts, the actions, Salvati's actions, were contrary to the testamentary disposition in Mrs. Goldstein's will. Based on all those factors, the court understandably required Salvati to return almost $300,000 to the estate that would have then been distributed 25% apiece to himself, his wife, and Lisa and Michael. And he got surcharged and, was given a very nice slap on the wrist by the court. So no shock in this discussion or decision, exactly how I would think a court would rule based on these facts. Bottom line is, power of attorney, the agent acting under a power of attorney has to act within the context of the power of attorney and what the rules and what the permission authorized in that power. And if they act in a way contrary to the testamentary plan, either the will or the trust the client has, they're going to get smacked down if someone challenges it after the principal's death. Good case for informational purposes and as a cautionary tale. So then we'll move on to Palladino. Megan, have a roll at this.
Sure. And this one, again, very good cautionary tale. This is a perfect case because it's sort of boiled down to the basics. In this instance, Mr. Palladino died, leaving spouse and 2 children. So in pretty much all of our examples, that's how it always starts out. Mr. Palladino's original will could not be located, but a copy of that purported will was located, and it said in there that it left the entire estate to his wife. And so that copy was submitted to probate. So again, very, very common fact pattern here, except for that the original will couldn't be located. So they're using a copy instead. Both children consented to the filing of that copy of the will. So everyone's on board with this. Yep, that was what dad's will was. We just can't seem to locate it. Our mistake. Everyone's in agreement. Mom should get everything. Even the drafting attorney submitted an affirmation saying that the decedent took the original will. So that attorney dug around, they didn't have it. And they seem to recall that at the end of the signing that day, the decedent took the original will with him when he left the office. That is something that is not done here in our office. And you all well know that. And usually we'll have a conversation about it. We keep our original wills here and we send you home with the copy. So exact reverse in this case. Decedent took the original with him. Decedent's son submitted an affidavit saying that he didn't think his father intended to revoke the will at all. It just was misplaced. And, maybe this was a situation where dad handled all the important paperwork, dad handled all the finances, he tucked it away somewhere, and now no one can really seem to find where that is. Despite the family's consent to the filing of the copy, the court here ruled that since there was no evidence that anyone other than the decedent had possessed the original will, the legal presumption, so there's statutory law that says there is a presumption that the decedent revoked his will. So unless they can show something otherwise, some reason that this will is missing, and it wasn't that he intended to revoke it, then we can't use this copy of the will. There's no clear and convincing evidence in this case presented to the court to rebut the presumption. There was nothing the family could offer to say, there's some excuse that the original is not here. All they could say is, we're pretty sure that dad, husband, client, he didn't want to revoke it. He had the original, but his intent was not to revoke, but nothing, no evidence to substantiate that. In the absence of a valid will, the decedent is deemed to have died intestate. So they're saying, nope, we can't accept the copy. So in this case, we're going to treat the estate as though he never executed a will. Unfortunately, what that means is that under New York State's intestacy laws, the spouse receives the first $50,000 of the decedent's assets. The remainder gets divided 50% to the surviving spouse, 50% to the surviving children. So here, the disposition of his estate is not going to go according to his wishes if he really did not intend to revoke that will. Instead, spouse is going to get some, kids are going to get some. If everyone's in agreement, maybe they're going to be able to work this out amongst themselves, but this is just not an ideal situation. And the mistake was that the decedent took the original will with him.
Right. And so let's say the kids who seemingly were all on board say, all right, we're going to give mom the assets. Well, there's a couple of things. If the children have no kids of their own, they could do a renunciation, and then by law, it will go back to mom. But let's say they have children, they can't renounce. They'd actually have to make a gift of those assets to mom. And if it's over the annual exemption now of $13,000 or $17,000, they would have to file gift tax returns and all that. So mom can get the money, but it's not nearly as clean a proceeding as they would have liked to have.
Yeah, huge hassle, not worth it. And they paid someone to do the will, so it's really unfortunate that this is the way this one played out. But that's why, just sort of, again, cautionary tale, that's why we keep your originals here. Very few people insist to take their original with them, and for good reason.
Yeah. So as we do every year, we like to finish this with a planning spotlight. And now, having over 2 decades under our collective belt of having estate plans of this nature created, and unfortunately these plans coming to fruition, as it were, with people passing away, we just want to give you a rundown of what happens with your trust planning after you pass away. Now, we do have that separate trustee training workshop coming up in like a month or so, which goes into a little bit more detail. But this one is really focused on the death aspect, not any of the disability and so on. So we'll take a run at this and give you a little insight. So as far as trust administration goes, what happens when you die? Well, as we've mentioned in past conferences and seminars and workshops, or however your nice red books don't become magic books when you die. They don't spring arms and legs and heads and run around and do things. People have to administer the estate and the trust according to the terms of the trust, and we want to make it as seamless and expeditious as possible. So the successor trustee you name in your trust, whether it's a spouse, if you have a surviving spouse, one or more adult children, or someone else entirely, will work with the law firm and any other professional advisors, accountants, financial advisors, etc., to ensure that as smooth a transition as possible from the main trust to any sub-trusts that are created within the trust instrument itself. So for married couples, and again, these are generalities, there are exceptions to every case. This is the most common disposition that you see in a married plan. After the first spouse's death, the assets that will be either in the revocable, or if we did a Medicaid trust for you, will remain typically in further trust for the surviving spouse. In most cases, 90% plus probably, the surviving spouse will be a trustee. Where that may not be the case is in like a blended family situation where there's, some concern about giving the surviving spouse access to the assets, but not direct control, so that those assets will ultimately pass to the deceased spouse's heirs and not the surviving spouse's heirs. Again, a case-by-case basis. In a revocable trust structure, typically the surviving spouse or the deceased spouse's assets will pass into a marital trust for the benefit of the surviving spouse. And in rarer cases today, a family trust for the benefit of the surviving spouse and descendants. Why the family trust is not as often funded these days is because of the larger estate tax exemptions. So typically we only fund a family trust in whole or in part in larger states, typically 6 million and up, if needed to shelter the deceased spouse's assets from further estate tax liability. If the total estate is $2 or $3 million, we don't really worry about state or federal estate tax. And the benefit of the marital trust is we get a step up in cost basis after the second spouse dies, which we would not receive in a family trust. So visually, and you may have seen this slide in our standard, starting workshop for prospective clients, we have a husband's revocable trust and a surviving spouse's revocable trust. Now, this same kind of scenario will play out even if we do a joint revocable trust for the clients. This will just split, if the single trust will split into these sub-trusts for the deceased spouse. So here, using the separate trust model as an example, husband and wife typically co-trustees while both are alive. After the first spouse's death, and as you know, we always kill off the husbands first in our example, assets can flow either into the marital trust down here, get my little laser pointer, into a marital trust, and or a family trust. And we typically use what's called a Clayton election that allows the surviving trustee, typically the spouse, to pick and choose assets to either go in the marital or family trust. We can shelter again up to the 6.58 million amount in the family trust if necessary for estate tax exemption purposes, and we can even go up to almost 13 million in the family trust for federal, but that would require payment of a New York State estate tax. So more than likely, if we did have someone had such a large estate, let's say $12 million, we'd probably park the 6.58 million here, and then the extra almost 6 million in the marital trust. Surviving spouse will continue to use her assets as desired at that point here in their own revocable trust. And more likely, if it's a non-blended family, the surviving spouse will be the trustee here with one or more children listed in order after that provision. So the key word here is flexibility. We want to have options for the surviving spouse to make the informed decision about which or either or both of these trusts to fund with the deceased spouse's assets. We would review this at a settlement meeting after the first spouse dies to go over the options and allow that spouse survivor to make the right decision. So the surviving spouse can be granted a power of appointment. I think last year in the update, we talked about powers of appointment, or the year before, one of the 2 years. The value, I think it was 2 years ago, the power of appointment is a very powerful tool. It allows a person who's granted a power of appointment to change the disposition of assets in a trust that is left for them, either to anybody, so it can be a broad or limited power. So if it's a broad power, you can leave as the power holder whatever's authorized in the trust to anyone you wish, those assets. So if it says by default, it goes to the deceased person's descendants, but if you are given a broad power of appointment and you want to leave some of that to charity, you can do so. In a blended family, you're probably not going to give a broad power or possibly any power. So the first person to die in their plan would say, upon my spouse's death, the remaining assets will pass as follows. So giving that survivor no authority to change it. But in your standard sort of single intact first marriage, sure, if the surviving spouse, wants to leave more to one child than to another, many people will say, well, he or she would have had good reason for wanting to do it. Why not give that authority since there are children together? So once the trust, the master trust funnels into the family or marital trust, we would obtain taxpayer ID numbers for these trusts. They are now separate legal entities. And we will prepare what are called trustee affidavit that will state, for the John Smith Marital Trust, Mary Smith is the trustee. Here's the taxpayer ID number. We attach the relevant pages of the trust to the affidavit so that Mary can now go to Fidelity or wherever the money is held and say, we're going to take it out of the John Smith Living Trust. Now it's going to go into the marital trust for my benefit. I am the trustee. And now Mary will continue to have access to that marital trust asset. So it's really just changing the name on the trust, not, she can keep the same investments if she wants and do whatever. It'll now just be a separate tax-paying entity filing a 1041 tax return. In a case of an irrevocable trust, typically it will continue in trust for the surviving spouse. We'll also get a tax ID number for that surviving spouse's trust. And the main difference is that in a Medicaid type irrevocable trust, which is what most of our irrevocable trusts are, the surviving spouse will only have access to income, but not principal. Principal typically can be funneled out to other people. And on the next slide, we have a diagram for that. So Megan, why don't you take us through the famous IRT diagram?
Sure. And a lot of people probably remember this from some point during the maintenance program or their initial meetings, but for this irrevocable trust, it can be an individual or a joint irrevocable trust. And the setup is one that you're probably very familiar with. We'll transfer certain assets into that trust during lifetime, right? And the terms of the trust say that while you're alive, and then even for your surviving spouse after you pass away in an individual or a joint situation, that person is entitled to income only. You're not allowed direct access to the principal. And that gives us, specifically in that Medicaid asset protection trust, that gives us that protection for those assets that we are looking for. Now, those transfers that you've made during lifetime, that's subject to the whole look back period, everything that you're familiar with. Once we're past that, they're protected. But really what we're focusing on at this point is the after death portion. So this stuff is normal. It's what you're used to. You probably remember you set up yourselves as trustees to start off, and then you have your successor trustees listed. Maybe you've made changes to those during your lifetime, maybe not. You have the option if you did want to change the order, but not everyone does. And so the nice thing about having that built in, the perk of having a trust essentially, is that should you pass away, your helpers are already listed. We will get that affidavit like Rich told you. And then that way, when you've passed away, maybe it's just the surviving spouse stays on. There's really not a whole lot of documentation needed for that because the trust is very explicit in that. But maybe it's surviving spouse serves with a co-trustee, or maybe it's co-trustees taking over. In that case, we want to have those affidavits prepared so that it's very, very easy for your successors to keep moving on and administer the trust itself now that you're not around. Like Rich said, if we needed to access some principal, if there is a surviving spouse, they'll still retain the right to make distributions out to those other designated beneficiaries. So this is important, especially if it's an individual irrevocable trust, because the trust maker has designated who those beneficiaries are. And so the surviving spouse will still be able to make those distributions to those individuals and work with those individuals to distribute principal out to them. And then, like we said, for the surviving spouse in a joint trust, the trust is just going to stay in place. There's no successor trust really created for the surviving spouse. It just remains the same trust document that you signed together with access to income, no access to principal directly. All the terms of the trust are still there. In individual irrevocable trusts, which we see far fewer of those now. Honestly, most of the trusts we draft are joint. So maybe one or two of you on this Zoom have an individual irrevocable trust. If that's the case, your trust is going to be a little different. Your trust is going to say, after I've passed, the assets will be held in a separate trust for the benefit of the surviving spouse. Same terms though, access to income, no access to principal directly, can distribute out to those other beneficiaries that you've designated for your trust. And so your successor trustee provisions are all there. And then certainly we have the provisions in all of our trust instruments, not just the irrevocable, for what happens after the death of the second spouse to pass away. I think we get into that a little bit as we move forward, but you'll see here additional trusts set up for those kids. And those offer those protections for your children or other beneficiaries that you may have designated, so that they're protected against creditors and divorce and their own long-term care concerns or disability, and maybe even some bloodline protection if you've incorporated that into your planning as well. And I think we're going to get a refresher on that. Anytime you do see a power of appointment, specifically a testamentary power of appointment for a surviving spouse, but also for your other beneficiaries as well, this is going to be something that's exercised by will typically. So after the death of the first spouse, if the surviving spouse does have that power to make the changes, the power of appointment, they're going to do that by updating their will. And in their updated will, they're going to say, I was granted this power of appointment by my now deceased spouse. And I would like to change the dispositive provisions of my trust that I've inherited to allocate those funds to the certain other beneficiaries. So that's the way they maybe can incorporate a charity or bring in the grandkids on the next level, or make changes if there was a falling out with a child or anything like that. So you're typically going to see that in a will. In our planning, we do also try to include that in your trust agreement. If you do have a revocable living trust, we'll like to see it in both places. So we'll typically update both of those for you. And then often the language will also say that you can exercise this power in other instruments, as long as that's specifically listed with your power. So typically that's going to be something like a notarized document. So trust for children, like I said, when we were looking at that illustration 2 slides ago, after the second parent's death, assets are going to pass to the children or even any other beneficiaries that you may have listed. It may not be kids in every scenario. And this can happen via that exercise of power of appointment if the surviving spouse did utilize that. So we will see that change become effective after the death of the second spouse. So as long as one spouse is surviving, they're signing that paperwork, but it doesn't become effective until they've passed away. In trusts, like I said, we're typically drafting for the children or the next layer of beneficiaries to receive their inheritance in a lifetime protective trust. So you probably remember that as we go through the design and counseling phase of your planning, and in your restatements, we focus on those trusts for the kids or your other beneficiaries. So here we see in the illustration, upon the second death, in this example, it looks like we probably funded that family trust, probably because of a tax consideration, right? So here the funds are going from that family trust to those subtrusts for the 2 children in this example. And you would have designed those trusts for the kids. Maybe we said we have no concerns about the child's ability to manage finances. We just want to make sure it's protected from outside elements, some bad people that could come in, creditors, predators, divorcing spouses, all of those things. Or maybe you said, I am a little bit concerned about how my kid manages money. There's been a history of some issues or bad decisions in the past. And so you would have designated maybe some more specific terms in their trust share. You might have said that they can't be their own trustee. So you've designated someone else to serve as the trustee. Certainly in an instance where there's both the marital and family trust, the distribution of the assets, it's going to the same place. So what I just want to emphasize here is that when you end up with trust shares for your kids, we do as much planning as possible to say, we don't want each child to end up with a bunch of trusts all over the place. So when the assets are coming from one, say, revocable living trust, and it's coming then to the marital and family trust, the terms of those trusts say assets for child one will be held in a single trust for child one. They're not going to end up with one trust from the marital, one trust from the family. And then in an instance where we have another revocable living trust, they're going to end up with a whole different set of trusts. So we do a lot of building in provisions to consolidate. So it's easy for the kids, the trust shares, as long as they're the same, we want the kids to be able to administer just one instrument for themselves.
Right. So with the trust for children, just like with the marital and family, we would obtain a tax ID number and prepare the trustee affidavit for the child's trust. As Megan just mentioned, when we do have those multiple trusts from a revocable trust or separate spouses revocable trust and a Medicaid trust, there's merger provisions that allows us to create a single administrative trust for the child, make it easier. The only trust we really can't merge would be a retirement type trust with a non-retirement, because there are very different rules apply to those accounts. So that would be the only time typically your kids would have possibly two separate trusts. So before we move on to any questions that anyone else may pose, Megan, just to give a rundown of the process for here from the clients about the individual updates and so on.
Sure. Yeah. So as you're probably familiar with by now, a couple of years doing this by Zoom, Lauren does go through the attendee registration list. She gets those worksheets sent out to you. So if you've mentioned that your preference is email, she would have emailed them to you. Otherwise, she'll send them out by mail. So all of your worksheets have already been sent out. Maybe some of you have received them already. When you get those in, you're going to want to fill them out. Even if you have no changes, please just check off no changes, send them back to us, review your funding, send that back to us. And then once we get that back, we will contact you to schedule that one-on-one restatement meeting, and we'll get all the documents prepared for that. Typically your restatement meetings are going to be scheduled with May, who I think probably all of you have met at this point. She's been around for a little while. So you're going to call and schedule an appointment with May. If we get a worksheet back from you, we haven't heard from you yet, that will also prompt us to reach out to you and make sure we get you on the calendar. Typically we're booking up about a month out. So if you do have some vacations planned and you really want to secure a date, even if you haven't gotten that worksheet just yet, give us a call and we'll kind of work you into the schedule and leave enough time for you to fill out the worksheets.
Very good. And I don't see any further questions posted. I did get one that I said I would answer offline, which I will do, so I have to just look up the information. All right, well, we kept this to a nice tidy hour and 8 minutes or so. A nice, I think, a good time frame for this process. This is again the first of several this year that we always do, and we're going to do a blend of online and in person. So we look forward at some point to seeing people either in group meetings or again at your individual signing meeting. Obviously, you know how to reach us: emails, phone calls, etc. It's part of the maintenance plan. You get that, and we look forward to a good rest of the 2023 and hopefully good, happy times for everyone ahead. So thanks for participating. Again, this is going to be on the website under the recordings fairly soon, probably within a week or so. So if you want to rehash some or all of this, you'll be free to access it there. So thanks for spending an hour and 10 minutes with us, and look forward to seeing you all soon. Thanks so much.